Board Member Turner, if you are back on the call and you're currently speaking, unfortunately you're muted.
This is Cheryl Turner.
Thank you. Board President, looks like everyone is back.
Okay, thank you. John, if you could go on.
Thank you, Madam President. So we're ready to proceed. All right, thank you, Madam President. Our next item considered school fees legislation. On April 9, 2020, the Reg Committee moved to adopt the staff's recommendation position of scenario 1 of the analysis of fund condition, and then to refer the position and amended school fee language to the board for approval. The Legislation and Regulations Committee now seeks to withdraw the school fee motion of April 29th and brings the following motion to the board. The committee would move that the board authorize the staff to seek legislation to charge school program fees for reviewing, processing, and monitoring various functions of school programs in the amounts as follows. $25,000 for the filing of an application for approval of a new school program, but not more than $50,000. $25,000 for authorizing the continuing approval of an existing school program every 4 years, but not more than $50,000. $5,000 for the processing and monitoring of a school program on provisional approval every 6 months, but not more than $10,000 every 6 months. And school programs on provisional approval for 3 consecutive years will result in the board's removing the school program from the list of approved schools. So that would be our motion, Madam President.
Thank you, John. Do board members have any questions? I see Carol had her hand raised.
I just wonder if there's going to be any provision, this is Carol Mountain, I just wonder if there's going to be any provision for community colleges, because paying a $25,000 fee even every 4 years in the current climate could result in the closure of LVN programs at the community college level, which would, for me personally, I think it would be very sad for those students that are underserved.
My recollection, Madam President, is that the board did consider that before, and I would defer to the executive officer any more detailed information.
Thank you, Mr. Chair. Dr. Mountain, yes, we've had a lot of discussions about this, and right now I think the path forward is so very, very uncertain that at this point in time, what we would like the board to consider is just laying out this as our baseline parameters. But a number of things, a number of parameters and alternatives can be discussed. And we've discussed a lot of different scenarios, one of which being a public versus private fee level, one of which being a waiver for a program that essentially this fee would force them out of business, things in that vein. So I think to your point, we absolutely understand, and certainly we're sympathetic with the public schools that do such a great work, a lot of work, and don't have the ability to raise fees as your private counterparts do. So as I said, I feel like at this point, what we would prefer to do is proceed with this motion, and then as we go forward, once we even have a bill in print, for example, we would be able to go back and discuss this, because it's our intention, of course, to have a number of discussions with stakeholders going forward. Does that respond to your concern?
Thank you. That clears it up a lot. Thank you.
Thank you.
Any other questions or comments? Donna?
Yeah, so like, I know we've had many discussions over this, over a number of meetings, but I don't recall, and it could be that I wasn't there for this discussion or that I just don't remember, but I don't remember hearing an amount. So hearing now 25,000, but not more than 50, I guess my question is, are those fees in alignment with what other boards are doing? I don't know how did we come up with 25,000?
Thank you very much. We did discuss some amounts when we discussed legislation last year, and at that point we were looking at more in the $15,000 to $20,000 range for the new program approval. But two things. One being that at this point in time, BRN charges a new school approval fee of $40,000. But we came up with this number after studying the workload of the NECs and sort of benchmarking what it really takes work-wise to approve a school and then to approve it for continual and to work with them on provisional. So these fee levels are based on something of the cost, and I will absolutely point out that this is substantially below what it costs to run our education division, but this is about a ballpark of what the NEC's workload would represent.
Okay, thank you. That answers the question.
Great, thank you.
Ken? I see your hand raised.
All right, I'm taking it back.
Thank you. Any other questions or comments? So there's a motion. Oh,
I'm sorry, this is Paul Sellers. I will make a comment. This was discussed
okay, Paul.
in the past. This was discussed in the past, and my concern is still the same. It's somewhat in line with Dr. Mountain's, in that I think there may be an undue burden placed on community colleges. I'm also concerned that some colleges are more needy, frankly, than others. Some require a lot of assistance. Some require virtually none, and the better colleges are going to end up subsidizing the others. So I think there's a lot of problems in this. I appreciate Elaine's language, the executive officer's language about provisions and waivers, but without that in there, I'm concerned that this is just going to be a blanket charge on all of the universities, as opposed to perhaps a piecemeal. As these different colleges need assistance, we might provide it at a charge. That would be my preference. That's my comments.
Thank you, Paul. Donna, do you have more comments? I see your hand is still up. So there is a motion coming out of committee that the board authorize staff to seek legislation to charge school program fees for reviewing, processing, monitoring various functions of school programs in the amount as follows. $25,000 for filing of an application for approval of a new school program, but not more than $50,000. $25,000 for authorizing the continuing approval of an existing school program every 4 years, but not more than 50,000. 5,000 for processing and monitoring of a school on provisional approval every 6 months, but not more than 10,000 every 6 months. School programs on provisional approval for 3 consecutive years will result in the board removing the school program from the list of approved schools. Somebody have a comment?
This is Bernice Basti Martinez. Comment and somewhat of a question. If I understand correctly, when we talk about the legislation itself, the operationalization and the protocol and process always would be separate. Is my understanding correct? Or am I confused? Like usual.
This is Elaine. I'm not sure I understand your question. Could you maybe restate
Well,
that?
I pose this comment with the question because I hear my colleagues worry, and I think it's a very valid worry, that if legislation goes forward and actually is passed that only addresses cost, that there might not be any other alternatives or solutions in the implementation. And so I seek clarification that when there's legislation like this, the protocol, the operationalization, if it's passed, processing is not necessarily to be found in the legislation itself. Is that correct?
That should be correct because we would need to put in regulatory language to implement that.
So that somewhat answers some of the worry I heard about just everybody gets charged the same, that operationalization, protocol establishment, process establishment could include sliding scales or address many of the items you mentioned earlier.
This is Ken Swenson, if I may speak to that.
Please.
In its current form, the bill, if passed, will require the board to charge a minimum as indicated in the proposal. If the board wanted to exceed the minimum to go upwards from there, then there'd be a regulatory process required. But as written, the bill would fix a minimum for all programs. So the discretion of the board to depart from the minimum would be exercised through a regulatory process, but the bill language fixes a minimum, which would be required to be collected. Thank you.
This is Bernice. May I speak again?
Yes, Bernice.
Thank you. I really appreciate legal's help in that. If that is the case, I'm wondering if we want to amend this in some way so that if this actually becomes legislation, it allows some working a process to address schools and other circumstances where the minimum figure we're focusing on at this moment might not work?
Madam President, could I address that, please?
Yes, Elaine.
Thank you very much. I understand the board's great trepidations about imposing this fee, but let me first off put it in the very bluntest context I can possibly put. Absent this fee, and given the board's long-range fund condition, the only other alternative to remain solvent is to raise applicant and licensee fees somewhere in the neighborhood of $55 to $60 each. So keep that in mind, and we did discuss this both at the Ledge and Regs Committee and somewhat with the execs, but we did not want to advance that as a possibility before consulting with our stakeholders and with labor. But we've discussed over the past couple of years a number of ways to implement this fee, and staff has done quite a lot of analysis on what is practicable. A sliding scale fee is not as practicable as one might think. The NECs have indicated that's public or private, small or large. The workload to provide these services, and this is, of course, a fee for services, is remarkably similar. Really, the only variance tend to be around the program directors and the programs themselves' ability to respond quickly and effectively. In other words, turning in their paperwork correctly the first time. And a sliding scale fee or a small, large, public-private difference is difficult to administer. Having a waiver in place is slightly more practicable to administer. We've discussed a number of scenarios there whereby if a school can document its financial condition and that the payment of that fee would substantially close its doors, or whether or not there was other kinds of factors to consider. We've discussed a lot of these scenarios, and right now, I do want to point out though that for the boards that do have similar fee structures, there are not sliding scale fees, there are not waivers, and there are not differentiations between public and private. That being said, we're very, very cognizant of the burden right now of the public institutions. So I would pause here for any other comments.
Hi, this is board member Paula. This is a question for Elaine. So if we were to pass this bill forward, approve it as is, what are the chances, or what is the process actually to operationalize content that could help schools reduce their fees? For example, if a school remains in good standing, a school does a thorough job in submitting their application. Maybe they can apply, or they can negotiate a reduced fee so that they can continue to educate nurses that come from underserved communities. I think it's really important to identify how we can talk about like, what is that process going to look like if we were to put some text with regards to how schools can be approved and maintained in good standing. And I think that this is also going to motivate schools to stay in good standing, because then they don't have to pay, X number of extra hours because they did a poor job. And
well,
I hope that my question was clear. It's about the process.
Of course. Well, first off, let me give you a very, very broad outline of what happens after the board votes on this motion. If the board chooses to proceed and authorizes staff to continue working on this, we work with the legislature, either the Assembly or Senate committees, to see if they are willing to carry this language this year. And that's not a certainty by any means. Then, assuming that we are able to have language introduced, the author's office, the committee itself, and basically stakeholders, this will go through the hearing process. This will go through the analysis process. Folks will be able to provide testimony and evidence. And bluntly, there's almost never been legislation that was approved the way it was introduced. As I said, there are a number of scenarios that could be put into place here. Once we develop legislative language, it has to come back, and when it's substantively changed, it needs to come back. Given the contingencies that we're under in terms of board meetings, my assumption would be that we would meet with the Leg and Regs committee via teleconference, and the executive committee via teleconference when things are changed, if they are changed. And we would probably want to include the education committee as well. And thereby we're having a much more consultative process, which would be, I think, then ratified if need be. We would need to, with the president's concurrence, confer a special meeting, but otherwise, come to the August meeting. But as I said, this is entirely dependent on whether or not we're going to be allowed to move anything this year anyway. Now, I think, Paula, to your point, it's a little difficult, I think, because as you're describing your concerns, I was somehow reminded of my insurance bill, where I get a good driver discount and the discount for a good zip code and whether or not I park inside. That's not really a practical idea, but I agree that the concern that you raised and the concern that other board members have raised about schools that are providing a really important community service, who are serving underserved communities, certainly there should be some consideration in that. I do know, of course, that when the NECs evaluate all their applications, all those factors do go into whether or not that proposal should be moved forward. But certainly the fact of the matter here is to propose a new program and to have that worked on by the NECs is a large initial investment of work. BRN's practice, not that I would consider them the Bible of how to do this. BRN, once they accept a letter that proposes a new program, says, we have received your program, please send us this check. And only then will it go into the queue, and then at some point, an NEC will be evaluating that program. We would probably be following that pattern for the most part. But certainly, I think down the road, some discussion of continuing approval might be advisable. But I think to your latter point, I think you're absolutely correct that this fee structure really is designed to make sure that programs are doing a good job, not only in just filing their paperwork and maintaining all of their adequate requirements, but staying off provisional, and making sure that they're doing a good job, because it is then definitely absolutely in their best interest to do so.
Thank you, Elaine.
Thank you.
Paul, do you still have a question or comment? I see your hand raised.
Yeah, yes, I do. So we have gone over this several times in the last few years, and my concern remains the same, that if, we want more nurses, not less. If we increase the barriers to entrance, we're going to get less schools. I've already argued the point about better schools carrying the burden for other schools. All due respect, Elaine, you made a comment that, or at least the way this is proposed, there is a provision for sliding scale. That sliding scale is between $25,000 and $50,000. So you already are in a position to have to justify increases in price. I would suggest one of two things. Either, as Ken has pointed out, Ken Swanson, that once we set a floor here, that's going to, regardless of what you might say, once we set a floor, that's going to be the floor. I suggest one of two things. We either set the floor at a nominal number, $5,000 or $10,000 up to $50,000, which would give us more leeway, or secondarily, specifically put in language that says this is the floor with provisions for reduction or waiver as justified, or whatever the language is, but put in a specific language for reduction or waiver in this proposal, because once we vote on this, this is the floor, and this is what they will be charged regardless.
Right. Let me try and clarify one thing for you. When we place a range of fees in statute, that's not a sliding scale. That is, there's the floor that we will charge initially, and that the upper level is what we may charge in the future, so that we're allowing rise in costs for inflation, for a variety of other things. And yes, it would take regulatory action to change those fee levels. To charge a nominal fee, as you're outlining, again, I think the board needs to be reminded here that the revenue that is calculated from this level of fees, and we provided, I think, a number of scenarios that show what our fund condition looks like in a variety of different scenarios. Charging less than what we are outlining right now does not bring the board into as strong of a fiscal position, a fiduciary position. It's not enough simply to make sure that we break even. I think it's common knowledge that fiscal prudence indicates that a board plan for something of a reserve for economic uncertainties. The numbers that we've been working on, it would be hard for us to reach even a 3-month reserve, and that's a very, very small reserve. But again, when I said earlier, failing to produce the targeted revenue here basically requires us to seek higher fees from our applicants and licensees, and for the other fees that we charge for example, continuing education providers. Essentially, you know, we have a budget that we have to. There's a certain amount of revenue that must be raised to run this board. Now, again, there are some uncertainties ahead of us. We don't know what is going to happen in the next year or so with regard to our staffing fluctuations, for example. But the simple point is that we've shown a number of different scenarios of what our bottom line looks like under a variety of these fee scenarios.
I just want to state, I do recognize, I understand that I've seen the budget shortfalls. I appreciate that situation. I'm just concerned this one size fits all is going to discriminate against some of the community colleges, and again, the better programs that aren't costing us a tremendous amount of money, while some of the other ones are more burdensome, and I think they should carry their own costs. And that's not in this particular provision.
Madam President, Ken Swenson here. If I may be heard on a suggestion which would help move this along and allay the concerns that some of the board members have expressed.
Okay.
It may be possible to allow the board to have jurisdiction over possible waivers or reduction in the fees by inserting a paragraph in the proposed bill language that would permit or mandate the board to develop regulations relating to the waiver or reduction of the fees due to a financial hardship. If that were inserted in the bill could proceed, and then it would flag the issue during the legislative process. It may not end up being in the final version of the bill, but at least the board has put on record its concern about the effect of the fees on certain programs. If the board was inclined to do something like that, I would recommend the following amendment to the proposed bill language. It'd be an additional paragraph as follows. The board shall develop regulations relating to the waiver or reduction of these fees due to financial hardship. If that were inserted in the proposed language of the bill, it would allay the concerns and flag the issue for further review and allow us to move the matter along. Thank you.
Thank you, Ken. Donna, you have your hand raised?
I do. So this is a tough topic for sure. But what I keep coming back to is over the years, our LVNs in a lot of areas, they don't make a lot of money, and yet we pay really high fees because we are a self-sustaining board. So I think that we have to be aware that someone's going to pay, whether it's the schools or it's the actual licensee, because we have to be able to maintain the board. I think I somewhat like Ken's amendment, although it causes me to pause and think that with that language, then we'll just spend a lot of time with schools as they claim financial hardship. And I could be mistaken, but I think this 25,000 is for new schools, correct? For their curriculum? And I guess I don't see in here, like if someone can point me to what the actual language is. I mean, I tried to find it. Mr. Deerking rattled it off, but I thought I heard 25,000 for new curriculum, and then there's additional fees for curriculum reviews and provisionals and all of that, and schools get themselves into that situation, right?
I think you might be looking at an old version, because really the only three fees we're discussing are approval of a new program, the continuing approval, and provisional.
Okay, so the continuing approval is, so for the new school is 25,000, correct?
Yes.
And what is the continuing, like, so that is 4 years in order to be on the approved list of schools, is that correct?
That's correct. And that would also be 25.
That's also 25?
Yes.
Okay, and then what's the provisional?
A provisional, what we are outlining is a $5,000 per 6-month period, in reflection of the fact that schools often fix their problems quicker than, so rather than just have a flat fee for a 2-year period, we have something somewhat adjustable so that schools have that, and again, that incentive really to remedy their issues.
Okay, and how much work goes into the every 4-year one to remain on our list of approved schools?
I'm glad you asked. The staff actually put together a work study, which should have been attached in the packet, which outlined what your basic what the NECs actually do basically for each part of the process. And so there's an estimate of how many hours per transaction or per process, with a bit of a range. And it does vary, as we've talked about, from school to school.
Okay. And then I have one final question, and that is that community colleges, do community colleges also run RN programs?
Yes.
And the RNs are charging $40,000?
Yes.
Okay, so so the community colleges are used to these fees already. They just haven't had to pay it for their LVN program. Is that correct?
That's correct.
Okay, thank you.
Carol?
I just wanted to respond to Donna really quick. This is Carol Mountain. The community colleges, right now, we are not paying a fee to the BRN when they come out and do our review for the RN programs. If we do any curriculum revision that they consider major, it's a $2,500 fee for any curriculum revision, and we don't pay for curriculum revision to the BVMPT. So just that distinction, I think, is important. The other thing is this whole thing with national accreditation, that people are looking at getting national accreditation, not just for the RN programs, but for their LVN programs. and those fees are about $15,000 to $20,000, and then about $3,000 every year, just so you have some perspective.
Carol, are you saying that, like, I'm trying to put it in perspective, like, I am not on the education side of this equation. So are you saying then that you don't pay the every 4-year fee that we're thinking of to remain on the approved list for an RN program?
Not at this time. We have not paid it. Well, I was just approved, my RN program was just approved 2 years ago, and we did not have that fee. But every time we change our curriculum, what's considered a major curriculum change, we do pay a $2,500 fee. No fee for minor curriculum change, but anytime there's major curriculum change, that's a $2,500 fee before you even get started.
Okay, and so do you not know if you have to pay a every 4-year fee to remain on the approved school?
Up until this point, I have not heard. They could have changed it in the last 6 months. They have not sent out notice to us that they're going to impose a fee when they come to visit us.
Okay. Thank you.
Any other questions or comments? We have a motion.
Yes, when we discussed
Yes.
before, wasn't it 15,000? It was lower. Maybe Donna may have mentioned this. I don't know. But wasn't it 15,000 before? Miss Gucci.
If I may, this is Elaine Yamaguchi. Yes, Ms. Turner, when we laid this out last year, the amount was a bit lower. In the ensuing year or so, we've noticed a lot of perhaps undervaluing of the time. And so we adjusted our estimates.
Thank you.
Thank you. So we have a motion that requires no second because it came out of committee. And it is the board authorized staff to seek legislation to change school programs for reviewing, processing, monitoring various functions of school programs in the amounts as follows: $25,000 for filing of an application for approval of new school program, but not more than $50,000, $25,000 for authorizing continuing approval of an existing school program every 4 years, but not more than $50,000, $5,000 for the processing and monitoring of a school program on provisional approval every 6 months, but not more than $10,000 every 6 months. School programs on provisional the school program from the list of approved schools. Is there any public comment?
We'll be opening public comment in just one moment.
I'm sorry. I thought I was unmuted. I opened up the public comment, but it doesn't look like there's any public comment. So, oh, actually, we have one. Ike, I hope I pronounced your name correctly. Ike, I see you have a public comment. Your microphone is unmuted.
Okay, thank you. Yeah, my comment is that I believe that the fees as so proposed are kind of on the high side. A fee of $5,000 for every 6 months for programs that are for processing and monitoring, I think is kind of punitive and counterproductive. And the other two fees is $25,000 for new schools, and I believe it's really high. It's going to hurt the community, the general public more in the long run than help. And I'm suggesting to the board that if they're going to charge anything, we do understand the increase in the cost of living and the cost of administering the program, but the fee of 25 to 50, in my opinion, is too high, and I would like to recommend to the board, if they're going to charge any fee, not to be more than $5,000 for new schools, and those are no other fees. $5,000 for new schools, no other fees. Thank you.
All right, thank you for your public comment. Your microphone has been muted, and we have no further public comments, so I can throw it back to the board president, and I'll close the Q&A panel.
Thank you.
You're welcome.
Donna, you have your hand up?
Just so I can have this in my head. So this is this retro for school? So for the current schools, it will be wherever they are in the 4-year mark for maintaining on the approved school list. And for new schools coming up, so schools won't be assessed both, right?
Yes, that's correct.
Okay, thank you.
Okay.
Carol, your hand is up.
Accidentally, I apologize.
Okay, thank you. Further questions or comments from board members? Seeing none, we'll do a roll call vote. Paula?
I have a question before I vote. Is that okay at this point, or?
Ken? Mr. Swenson?
Unless the question relates to what is being voted upon, the vote should proceed, and then other matters can be taken up afterwards.
Paula?
Yeah, I'm going to abstain at this point.
Okay. Bernice?
All of a sudden, repeat the motion, please. I'm so sorry.
So the motion is that the board authorize staff to seek legislation to charge school programs and fees for reviewing, processing, and monitoring various functions of school programs in the amount as follows: $25,000 for the filing of an application for approval of a new school program, but not more than $50,000. $25,000 for authorizing the continuing approval of an existing program every 4 years, but not more than $50,000. $5,000 for the processing and monitoring of a school program on provisional approval every 6 months, but not more than $10,000 every 6 months. School programs on provisional approval for 3 consecutive years will result in the boards removing the school program from the list of approved schools.
Thank you. Abstain.
Camera, look.
Alita?
Alita Carpenter, yes.
John?
John Deerking, yes.
Ken?
Kenneth Maxey, yes.
Carol?
Carol Mountain, abstain.
Donna, I saw that you had your hand up also.
I was curious because Ken had suggested an amendment, but it didn't make it into the motion. That was why my hand was up. So on the current motion, yes.
Paul?
Paul Sellers, no.
Melissa?
Melissa Rubakava, yes.
Cheryl?
Cheryl Turner, no.
And I am an abstain. So 3, 4, 5, 6. So 4 abstain, 2 no, and 5 yes. So Ken, that would make it that it failed?
The motion carries by majority.
Okay. So the motion's carried. Thank you, John. And then you have one more?
Yes, for the Legislative Regulations Committee, Madam President.
Mm-hmm.
Yes, the next item relates to rulemaking action, Section 100, update from legal counsel. My understanding is legal will now weigh in and provide an update on Section 100.
Thank you, Mr. Chair. The Section 100 rulemaking change relating to the license fees remains under review with the Deputy Director of Legal Affairs. As a result of some changes at the Office of Administrative Law, the supporting documents had to be revised. Those revisions are underway, after which the matter will be referred to the director and, if approved, submitted to the Office of Administrative Law.
Thank you. Donna, you have your hand raised?
Accidentally, actually it was just filled up. Sorry, I have no question on this.
Thank you. Okay. John, does that conclude your report?
Yes, Madam President, that concludes our report, and the next meeting of the Legislation and Regulations Committee will be scheduled after today's meeting.
Thank you, John. That brings us to the Enforcement Division. Candace?
Good afternoon. You have a copy of my Enforcement Division report as well as the statistical overview for enforcement in front of you. Before I ask if you have any questions, I would like to say that in my review of our weekly, monthly, quarterly statistics, it's obvious to me that the effects of all of the hard work that we've done over the past year, 2 years, is really beginning to show on a sustained basis. We have a decrease in the number of the complaints that are pending investigation. We have a decrease in the number of cases that are pending at the AG's office. There's a decrease in the average number of days to complete formal discipline cases. And I just want to acknowledge and commend the Enforcement Division staff for all of their hard work and their dedication in this area. If there are any questions, I'm happy to answer those.
Seeing none, that'll bring us to the Enforcement Committee report.
Thank you, Madam President. So it's been some time since this committee has been given the opportunity to make a report. And so I just wanted to ask the board to indulge a little bit. I'll give you kind of a background of what's transpired over the last couple months. And the great work that Candace and her team at the enforcement team has done. And so going back to January, the board staff had brought the issue of potential problems with the board's current process for handling petitions and reinstatement, modifications and probation, and early termination of probation to the enforcement committee. Since then, we've had a couple conversations and had some potential decisions that we had to make. And thank you, board, for indulging and making sure that the ask from Elaine and from Candace was met. Most from our special board meeting, where we were trying to ensure that 7 petitions that were scheduled for a hearing in May were able to move forward to the administrative law judge. We are yet to schedule an upcoming committee meeting, but that is, and it's in the notes, is the update that we have as of today, Madam President.
Thank you, Ken. Do board members have any questions? Seeing none, we'll move on to the board calendar discussion and possible action.
Apologies, this is the moderator. Board President, did you want to open up for public comment?
We can open up for public comment.
Okay. I will turn on the Q&A feature now. Members of the public, if you would like to make a public comment, please access the Q&A feature at the bottom, which is the question mark in the box. You could please click that icon. We should be sharing the instructions momentarily. And I will pause one moment to allow the public time to indicate if they would like to make a public comment. Board President, it looks like no one has indicated they would like to make a public comment. Would you like me to go ahead and close the Q&A panel?
Yes, please. Thank
Okay.
you.
Q&A panel is now closed.
That'll bring us to number 11, the board calendar and discussion and possible changes. So, Elaine?
Thank you, Madam Chair. Pardon me. The agenda item 11 in your packet spells out basically the factors that the board will need to consider. Just to preface that, we don't anticipate being completely out of a state of emergency by the August board meeting, and we certainly don't have any indication that we would have adequate time at this point to enter into a contract to hold a meeting as we usually would do in Southern California. Right now, I believe that our options are our best options, if not only options, are if the board wishes to meet in person to hold that meeting up in the Sacramento DCA headquarters, or the board may consider a meeting much like this one via WebEx. We've outlined a number of facts to consider in that decision, but I kind of wanted to outline that our strongest recommendation would be to continue the pattern that we saw today, and to essentially plan to have an August meeting via WebEx. And at this point, I would pause for questions and comments.
So this is Donna.
Yes.
So we would be having a one-day meeting again in which we would not be hearing petitions for reinstatement if we did it via WebEx. So those petitions would go the same way that they did this time. They would go to hearing.
That's actually a second question.
Well, isn't it all in one question though? Because if we vote for WebEx, we can't have petition hearings via WebEx.
Well, let me at this point defer to the enforcement chief.
So my team and I have done a great deal of research into this in advance of this meeting to try to answer some of these questions for you. We don't know a lot more now than we knew before, but we have spoken with the Office of the Attorney General. We've spoken with the Office of Administrative Hearings, and they've all been pretty non-committal when it comes to telling us what they will or won't be able to do when it comes to an August board meeting. What I do know for sure is I spoke with a Deputy Attorney General yesterday. So after the last meeting and you approved us to refer 7 petitions over that would have been heard at this meeting, at the April 24th meeting, you made that motion. On April 28th, we did that. We sent those over. 5 of the 7 have been scheduled for hearing. 2 of the 7 were heard earlier this week, and so I spoke with the Deputy Attorney General who handled those just to kind of get her feeling as far as how the hearings went and kind of her thoughts on it. She said that they went very smoothly. She didn't have any concerns. She said there were a couple of hiccups when it came to OAH's equipment, but that overall it went very smoothly, and so they were able to complete those. I asked her about the possibility of using a WebEx platform or something similar, and she said that she felt like the challenge there would be the fact that OAH and the AG both use different platforms to accomplish those types of hearings. And so if we were to do something like that, it would generally have to be on a WebEx platform like we're using now, and that it would be something that would be initiated by the board, and then we would join in the AG and the ALJ as well as the petitioner. So that kind of, as you know, you've seen the challenges that we're facing now as far as doing this WebEx meeting. At this point, I basically, just want to present the information, and then it would be up to the board to decide if you wanted to do or to give that a try. Otherwise, my recommendation would be that we go ahead and move forward with sending the August petition hearings to the Office of the Attorney General for hearing before an ALJ, similar to what we're doing with the May petition hearing.
And this is all with the assumption that we will not be able to have an in-person meeting in Sacramento in August.
Let me respond to that. Ms. Norton, this is Elaine. We may be able to. The department has not given me a solid yes or no whether or not they would even permit a public meeting. But even if they did, we would have to create a very, very different scene, I think, for the meeting. We would have to initiate the very, very pronounced social distancing. We would have to make sure that the microphones had those sanitary covers. We would strongly recommend that everyone be masked and possibly gloved. We would strongly recommend checking temperatures at the door. We would definitely be limiting audience. In fact, we would probably not have an audience at all beyond staff and probably the petitioners as they came. And the board itself would not be able to use that dais. We would probably be creating a larger sort of horseshoeish look so that people could sit every other seat. You're familiar, I think, with that hearing room. But it would look something like that. And again, I think not to put too fine a point on it, we would need to make sure that, one, the petitioners were willing to travel to Sacramento, and actually that the board members themselves would be willing to travel. There's still no indication of that lessening in its hazards, let's just say. We would need, of course, at least 6 of the board members to make up quorum. But we would also need, of course, to secure lodging at this point for the board members. A lot of the hotel rooms are either occupied or not operational. It would be difficult, but I wouldn't say it would be impossible.
Okay, thank you.
Any other board members' comments?
Yeah, this is Paul Sellers. I have a comment here. My position on this is that Elaine has described not knowing, this possibly going on for months, perhaps years, I think she said earlier. I think advocating this responsibility to the AG one time was fine, but I think we now need to figure out how we're going to hold these hearings. Again, I understand the limitations on meeting in person, and I actually don't suggest that, but I think we need to figure out how we're going to do this on a WebEx platform. I think that's what needs to happen at this stage. We've had a month and now 3 months ahead of us. We have a third of a year to figure this out. If the AG can do it, I don't understand why we can't do it.
Actually, I'm glad you mentioned that, Paul. This is Elaine again. The National Council actually has been discussing this at great length. And at this point, probably most of the states have been, if not actually performing their hearings via an online platform or actually delegating them, they're at least planning to do so in the near future. There's going to be a webinar on this on June 10th, I believe. And I should send out the link to the board members because I think it'll be a very, very interesting discussion of best practices for one thing, but also the caveats. I understand and I really appreciate your concern for the board's ability to provide this very important duty. We have, of course, the alternatives of we could gamble on the idea that November would be somewhat much more relaxed and flexible, that we could hold 2 consecutive days of hearing and make up for it then. Or we could again, we could delegate, or we could try to set up the via WebEx.
This is Paula. I do believe that we will most likely continue to be safest if we continue to do a WebEx or remote meetings. And I don't think we should be exposing ourselves or any of the healthcare workers who might be attending the meeting, potentially exposure to the virus. And I also believe that, like Paul said, we need to start looking for solutions on how we can do remote work and how we can hear our petitioners. And so I'm open to perhaps a meeting to brainstorm, or have the staff think about how we can continue our business, hearings and business board remotely. And I think that in this age, we should be able to find solutions on how to do this. And I think that if audio, at this point, I think it sounds like it would only be audio given the broadband video problem. So I encourage the staff to continue planning for how we can do this remotely.
Thank you, Paula. If I may, this is Elaine.
Thank you.
One thing, it seems like the best alternative going forward would be to convene hearings via WebEx, as assuming that all the other parties are agreeable and that we can. It is possible to do video, but DCA has strongly urged us not to, given the bandwidth demands. But it would be our studied opinion that should the board want to proceed with the hearings via WebEx, that we would actually shorten that agenda to maybe 5 or 6 petitioners and no more than that, just based on the potential for technical difficulties, among other things. But as I said, that would be our strongest recommendation right now.
This is Cheryl Turner. I would agree with that suggestion that we at least try, even if we have to reduce the number of petitioners. We are the monitor or the moderator, not sure her title. She already said she attempted to do that with another board. So it's possible to have the video access. And we were supposed to have a response back for this meeting about how we could accomplish it so that we could participate. And I think that the board should take every effort to try to fulfill their duties to the extent that they are able, because you keep delegating your authority and abdicating your ability to rule upon these cases, then you're going to find that you're no longer necessary in this process. Thank you.
Thank you, Cheryl. Bernice, I saw that you had your hand up earlier. Bernice?
May I ask another quick question?
Yes.
This is a question, a technical question, probably to the moderator or maybe Jay, but I don't know the back end of WebEx very well. Can you open a single stream of video? In other words, all of the board members and participants would not have video, but we could open it up so we could see the petitioner. I think that was one of the concerns, was being able to assess their presentation. Is that possible?
It is possible. This is another co-moderator. We have had some boards experiment where the board members will not show video and the petitioner will.
I would think that would go a long ways towards meeting the goal of not eating up bandwidth, but it still give us that ability to, again, observe the petitioner and how they present.
This is Elaine. I would caution the board about that, in that we would have to make certain that the petitioners had secure access and with video capability.
This is Dennis again, or the moderator again. That's a good point. The petitioner would have to have a good internet connection, or just an average internet connection, and a camera and a microphone on their computer.
Couldn't we open up the PCA hearing room and just have the lawyer and the petitioner, give them even separate tables? I know we have a couple of tables. We could distance them inside that room and provide the feed ourselves.
That was my question exactly, Paul. This is Alita.
To respond to that, this is Elaine. To respond to that, first, again, we're not certain that DCA would be able to provide any public access. Secondly, we don't know, even if they do, what staff would be administering that there. It creates yet another obstacle, and especially if our staff is on furloughed, it again creates a little bit more of a difficulty.
So Elaine, this is Tammy. So my question would be in regards to the Open Meetings Act. So now if we choose to hold this WebEx and the governor decides that he's going to lift some of the provisions up off of this modified Open Meetings Act, how would that be responded to? Because
that is an excellent question, and I would have to defer to counsel on that.
The answer to that question is, if the executive order lifting some of the requirements of Bagley-Keene is no longer in place, then the petition hearings would be public sessions where some access to the public would have to be provided.
But that would also mean that the board members' locations have to be publicly accessible, correct? And each location has to be noticed.
That's correct. If the current executive order is simply lifted, now it's possible it could be phased in as certain restrictions are lifted, or certain lifting of the restrictions and others remain in place. So it just depends on what happens as far as the lifting of the executive order.
So would it be feasible to say that potentially in preparation for the August board meeting, barring the plan in place, we may still have to be, the Bagley-Keene executive order may still be in effect, but if it's no longer in effect, wouldn't it be easier to plan for a board meeting at the DCA headquarters to reserve that just in the event that it is lifted, we need to have an in-person meeting? Because is it not easier?
Madam President, if I could make a suggestion, actually.
Yes.
I would suggest that the board go ahead and make a determination of how to conduct its August meeting and its hearings, and that the executive committee at its next meeting evaluate that, and if there has been any change in, say, the governor's executive order or the state of emergency, that we're able to amend it at that point. But that it would be essential that the board make a motion right now so that we're able to at least put some things into motion.
This is Bernice, and I would hope it would also consider maybe a double day of hearings so that we can address all that wish to be heard or who have been scheduled.
Yeah. Is there a motion?
I would make a motion. I would make a motion that the board prepare to host a online meeting August 20th and 21st to meet the commitments of the board meeting.
This is Carol Mountain. I would second that.
So there's a motion made by Paul to prepare to hold an online meeting August 21st, 20th and 21st to meet the board's requirement, and it was seconded by Carol. Did I state the motion correctly, Paul?
Yeah, that's correct.
Is there further discussion needed by board members?
Madam President, if I could ask for some clarification on 2 points. One being, I'm assuming that you mean for the August 20th to hold petitioner hearings, but could we clarify that the board agrees that we would limit the number to a smaller number than usual, say 5 petition hearings for that day?
Do we know how many are currently pending?
Candace?
You mean for the August hearing? We currently have 8.
Yes.
Yeah, I would agree to limit it to 5 if we could. Yeah, I would agree to 5 being a limit. This has gone pretty long today.
Carol, are you good with that?
Yes, I agree to 5.
Thank you. Any further discussion by board members?
This is Donna. So we're talking about having a WebEx platform similar to today for the August board meeting for both petition hearings and the second day of board business, correct?
Yes, that's correct.
That is my understanding.
Okay, thank you.
Any other discussion by board members? Any public comment?
All right, this is the moderator. At request of the board, I will go ahead and open up the Q&A portion now.
Thank you.
If you would like to make a public comment, please click on the icon with the question mark within a square located at the bottom center of your WebEx screen. We'll get the instructions up on the screen shortly. And I will pause for a moment to allow members of the public to indicate if they would like to make a public comment. All right, Board President, it looks like no one has indicated that they would like to make a comment. Would you like me to close the Q&A portion now?
Yes, thank you.
Okay, the Q&A panel is now.
Thank you. So there's a motion and a second to hold an online board meeting on the 20th and 21st for the August board meeting and to limit the petitioner hearings to 5 hearings. So we'll do a roll call vote. Paula?
This is Paula, yes.
Bernice?
This is Bernice, yes.
Alita?
Alita Carpenter, yes.
John?
John Deerking, yes.
And Ken is on another call for work, so he had to leave us. Carol?
Carol Mountain, yes.
Donna?
Donna Norton, yes.
Paul?
Paul Sellers, yes.
Melissa?
Melissa Rubacava, yes.
Cheryl?
Cheryl Turner, yes.
I'm a yes. Motion carries. Thank you. That will bring us to agenda item 12, public comment on items not on the agenda.
All right, this is the moderator. At the direction of the board, I will open up the Q&A panel now. Members of the public, if you would like to make a public comment, please click on the icon with the question mark within a square located at the bottom center of your WebEx screen. We're sharing the instructions right now for your reference. And if you would like to make a comment, please type "I would like to make a comment" in the ask field and click enter or send to all panelists. I will now go ahead and pause for a moment to allow any members of the public to indicate if they would like to make a comment. All right, I have one individual who would like to make a comment. Ike Myoku, I apologize if I mispronounced your last name. I will go ahead and unmute your microphone, and you will be given 3 minutes to speak. Once that time has started, I will also give you a 30-second warning. And after 3 minutes is up, you will be muted again.
Okay.
Your microphone is now unmuted.
Okay, thank you. We made an appeal to the board's decision regarding the status of our school, which was denied for want of jurisdiction. And I would like to ask the board who has jurisdiction to hear that appeal.
This is Ken Swenson, legal counsel for the board. This is public comment on issues not on the agenda. The board cannot act or otherwise respond to the question posed by Dr. Ike. It can be set for a future board meeting, but I can respond to Dr. Ike by saying that there'll be something sent to him in response to his inquiry. Thank you.
Okay, then if I may request for that to be set for a future board meeting then.
I will respond in writing to Dr. Ike. It's within the board's discretion whether it gets calendared for a future meeting.
All right, thank you, Ike. I have muted your microphone. I will pause for another moment to allow any other members of the public to indicate if they would like to make a comment. Board President, it doesn't look like there are any other members of the public who would like to make a public comment. Would you like me to close the Q&A portion now?
Yes, thank you.
Okay. Q&A is now closed.
That will bring us to agenda item 13, suggestions for future agenda items. If board members, if we could have you raise your hand to place the items or suggestions for future agenda items. Melissa?
Hello, thank you, Madam President. I had a just something I wanted to bring to the board, and I'm not sure if I need to bring it to the Legislative and Regulation Committee, but I wanted to review current law for psychiatric technician laws and regulation, Article 2, Chapter 10, Section 4516. It's in relation to the use of PTs, how they put the initials PT behind the name, and I really want to discuss further or have further discussion on how it relates to the Business and Professional Code Division 2, Chapter 5.7, Section 2633, and how it can kind of be confusing for licensed physical therapists, how they also put PT behind their name. And I just didn't know if that's a conversation we'd like to have down the road.
Ken, Mr. Swenson, would we direct that at a future board meeting, or would that be directed to be placed on the Education Committee?
It doesn't fall neatly with any existing committee. It may be something that, rather than taking it up at a board meeting, that the member may want to forward an inquiry to me as the general counsel. I can respond to that.
So send an inquiry to you?
That's what I recommend because it deals with an illegal interpretation.
Thank you, Ken. Melissa, did you get that?
Yes, thank you so much. I will email Ken. Thank you.
Thank you. Any other future agenda items?
I think we were going to have a follow-up report from Ms. Yamaguchi about the line item for the cost recovery.
Okay. Thank you, Cheryl. Any other items from board members for future agenda? Seeing none, is there any public comment?
This is the moderator. I will go ahead and open up the Q&A panel now. Members of the public, you should be able to access the Q&A icon at the bottom of your screen. And if you would like to make a public comment on this agenda item, please type "I would like to make a comment" in the ask field and hit send to all panelists. And we'll pause for a moment to allow members of the public to indicate if they would like to make a comment.
You okay? Are you done talking?
All right, I have one individual who has indicated they would like to make a public comment. Ike, I will go ahead and unmute your microphone, and you'll be given 3 minutes to speak. All right, Ike, your microphone is unmuted.
Okay, thank you. I hope my question is appropriate in this section. If not, please so direct me. But I just wanted to clarify, the gentleman that responded to my previous comment said that I will get a mail or email. I wanted to clarify which way that information is coming. Hello? Hello, did you get my question?
Yes, I'm about to respond. An email will not be sent. A regular letter will be sent by first-class mail.
Okay, thank you.
All right, and I have muted Ike's microphone. And Board President, it seems that is the last person to indicate they would like to make a comment. Would you like me to close the Q&A panel now?
Yes, please.
All right, the Q&A panel is now closed.
Thank you. That brings us. Yes.
Tammy, hi, this is Jay. All the board members have been sent and Ken emails with the call-in code for the teleconference for closed session and your participant pins. We just need to decide what time you guys would like to reconvene for the call.
I would say 30 minutes. Is that long enough for board members to Or do we just want to go straight through?
Hi, this is Donna. So,
There was a way. Saw that.
when were we sent them? So, like, I'm looking in my, who would have come from? Because I don't recall seeing any number for closed session.
It would come from Vicky Saavedra.
And I actually sent them as well yesterday.
Okay, all right. Literally getting thousands of emails now because everything's going this way. So I will search for Vicky. Okay, thank you.
Email
Donna,
specific 228, Donna.
Oh, I see
Today.
it. I see it. It went
Okay.
into my junk.
Oh, sorry.
That's okay. It's not, yeah, it's my computer's fault.
This is Alita. Could we have at least a 15-minute break?
Yeah, so how about we start at 3:30?
Actually, I agree with Alita. Let's just take 15 minutes and get this done.
I agree. 15 minutes. This is Paula.
I agree.
This is the moderator. Just to quickly interrupt, it looks like I have a raised hand from Margarita Valdez. I don't know if you want me to go ahead and unmute her to see if she would like to make a comment.
That's fine.
Okay. Margarita, I'll go ahead and unmute you real quick.
Hello. This is the last meeting I will be attending. I wanted to thank everybody for the opportunity that I've had with the board. I also wanted to, hearing everything today, I wanted to make a comment. Having been a director and having gone from one school to 6 campus programs and then coming to the board, it was an awakening. I have never worked so hard, never understood the amount of work that the board and the NECs do when working with the programs, from approving a proposed program to ongoing continued approvals to faculty approvals, and now what we are experiencing. It has been a time of learning. I felt extremely dumb when I came to work for the board. I felt like a new student. It has been a very challenging time, but it has been extremely satisfying. Thank you.
Thank you.
Right,
Thank you,
for your service.
Absolutely. Thank you so much, Margarita. You're going to be very missed.
Thank you, Margarita.
Margarita, this is Bernice. We really know you will not be replaceable. Thank you for everything.
Thank you, Margarita. I concur with Bernice. You will be missed. And thank you for all the work you've done. So with that, we will convene in closed session at 3:15. If we can call in on the numbers provided for the closed session, we will adjourn the meeting at 3:01. And I'd like to thank the board and board staff for all the work they've done in preparation for the meeting, and especially our licensing, our 4 licensing people who were awarded the award. Thank you.
All right. This is